Judiciary Committee this Tuesday afternoon, April 22nd. And we're going to start by hearing from the reporter on S36. Some might be wondering why we're looking at S36. So the main part that we need to talk about and understand has to do with the inebriate program. What does PIP stand for again? The
Public inebriate.
Public inebriate program, which we actually have similar language or similar issue in S109. So we want to understand what Health Human Services or Human Services, is doing with that component of it. And if it looks like it's being taken care of there, we can take it out of our bill. So welcome please join us, Representative Bishop. And identify yourself for the record and tell us what you've done with that part of the bill.
Yes, Representative Doug Bishop of Colchester from the House Human Services Committee. So yes, the bill has Medicaid in the title, which makes you wonder even more why it's here. It's sort of a bill in three parts. Medicaid payments for residential treatment. Another component relates to the Human Services Board. The component of interest to this committee does relate to the public, what's referred to as the public inebriate program. And that was put into the bill on the Senate side by the committee. It was not as introduced, but added. Previous legislatures had put into statute a prohibition against using the Department of Corrections as a place to lodge public inebriates. That has been postponed. Implementation of that has been postponed several times. And what came over from the Senate was a repeal. And that, to cut to the end, that is also what was included in, as passed by the amendment by House Human Services, that a repeal would be an appropriate step. So by backing up a little bit by way of some history, and the language public inebriate, as your House Human Service colleagues are prone to do, we look at language and we are going to be making a change to inebriated persons who are inebriated, or excuse me, incapacitated, rather than using public inebriates. But when someone may come into contact with law enforcement or otherwise because of their state of being incapacitated, the law enforcement does have the option of finding them a suitable person at home or otherwise who can watch over them. This is not a criminal offense, it's a civil matters. So first course is to try to return someone to a safe location, as I said, home or otherwise. There are also instances where there is concern about the medical condition of the individual, and they would be taken to an emergency department for them to be evaluated, but not lodged. It's not the intention to take them there to lodge them there. But there are also occasions where someone is in not need of any medical attention. The local police most likely do not have the capacity, either physical space or staffing, to be with someone who is incapacitated and waiting for them to, for lack of a better term, sober up. And so the Department of Corrections has been used to lodge individuals. Another option, and what we referred as we got started here, PIPs. There are public inebriate programs. So you're not returning someone to home. They don't need medical care at a hospital. There are a few options in the state for public inebriate programs where someone can be taken with those, and this is staffed by individuals with training dealing with folks who have substance use disorder issues. And that is, if you will, probably best practice and preferable. The problem is there is a lack of public inebriate programs in the state. And in fact, Chittenden County, our most populous county and where there's the greatest need, had one that has since closed down. And so Lamoille County faces a similar fate where a public inebriate program, or PIP, the PIP beds, closed down. So the option for taking someone to Department of Corrections, well, not a first line choice or preferable, sometimes has remained the only option. And there are also instances where someone is potentially not only a threat to themselves because of their condition, but they could be violent. And there are instances where being taken to Department of Corrections, they are not arrested. They are held in sort of a holding area. They are not put into general population. And in fact, we heard very passionate testimony from the nursing community about concerns that as a default, the emergency departments become a place where someone who is incapacitated is lodged. And they can be combative, that can be physically dangerous, as per their testimony on some instances. And as this body has, under another piece of legislation, taken steps to protect medical providers, they see this as a public safety issue for them as medical providers in the ED setting. We also heard from those who run public inebriate programs and why they are glad to do their work and glad to have the referrals. They themselves acknowledge there are times when someone arrives at their program who is not appropriate for that due to the potential for violent outbursts or otherwise. And even the operators of the public inebriate programs have indicated they would like the Department of Corrections to remain an option. We spoke with local police who testified before our committee, this representative of one department who indicated the same. So with basically all who provided testimony before our committee from different components to how we address this issue, testifying that Department of Corrections is an option that they would like to have remain available. Our committee concurred with the Senate proposal to, at this point, simply repeal the prohibition, not having it go. It has not previously gone into place, and we would just repeal it at this point. To recognizing that the public inebriate programs can be the best practice, best option, the Agency of Human Services would agree with that, and they have a 2-year plan to try to improve and build out the availability of public inebriate programs. A big obstacle, significant obstacle would be the staffing. You don't know when you're going to use it, so staffing 24/7 for a PIP is challenging. So their plan is to look, and they're working with people in the community where there are crisis beds exist for mental health crisis beds to co-locate, since those are staffed 24/7. So they have a 2-year plan. There's funding in this year's budget as requested by the governor and as is working through the process. And so we have amended S36 to do a couple of things. One, which is to prioritize Chittenden County. It was in year 2 of their plan, and that is a location by numbers where there's the greatest need. We asked them to prioritize Chittenden County and also to report back to us on their progress early in the next session. We've additionally asked the Department of Corrections, who prior to COVID would work with the local community providers to, if someone had been lodged at the Department of Corrections, to connect them with local community providers in substance use practice and to try to help that individual rather than simply be a place to lodge. That practice fell out of use during COVID, and we've asked Department of Corrections to get back to us in early part of the next session as to a plan that they think is feasible for them to put into place so that they can once again connect individuals who are being lodged at DOC with services in the community. I think that covers what testimony we heard and the approach we've taken in the amendments to S36.
Questions? Karen in the Bible.
Thanks for this update. And so you shared that the PIP programs are the preferred place for folks to go, but they are not well resourced or out there as could be, but there's a plan to get them there. So I see how having the DOC is important, right? To have it there. I guess I'm curious if I don't know if it's statute or regulation, something that it's known, like go with the PIP beds first before go to the DOC beds. Like how does that get? Because I guess that's what I would want to know is if we have DOC beds there as a backup, do they know if PIP beds are available? Like that's what you go to first if it's appropriate.
We did not come across any testimony or any sense that local law enforcement are unfamiliar with the PIPs or that they would have any hesitation in using the PIPs. And to be frank, practically speaking, it is most often the easiest solution for them. If I take my own community of Colchester, when there was an option in Burlington, that was just much more practical, in addition to being best practice and what law enforcement would want to happen for this individual. It's a lot more practical for them to take someone to Burlington than to take them up to St. Albans, to Northwest Correctional. So we have not encountered any resistance in the community or heard of any resistance to using the PIPs. So I'm not aware of any rules, procedures, if you will. It's just
I
common
wasn't
practice.
concerned in your committee that
No.
they wouldn't be used.
Barbara, then
So I'm wondering, even if somebody's disorderly, there's not an issue with them being incarcerated. So I'm wondering why to swoop in incapacitated with, and give the repeal for them not to be able to go, for them to be able to go back to jail.
I'm not sure I follow.
Okay, so you mentioned there are times that the PIP programs or the ERs are coming across people who are belligerent or violent. Those people could be charged with other offenses, including disorderly or assaultive. So giving up the protection of keeping people who are merely incapacitated out seems like a big concession.
I guess the testimony that we did hear is concerns that in fact, someone who is not acting with any criminal intent or conduct may end up with a criminal charge, if they are in the setting of an ED where things are chaotic. They may not be. It adds a lot to the experience that they're already going through for them, and they may end up acting out then in a way that results in a charge. So we've got someone who is simply inebriated or incapacitated who ends up with a criminal charge. So
nationally, that happens to people in jail who are sent there for being incapacitated as well.
Yeah.
So it's been a gateway to people having more criminal involvement.
Well, we didn't take testimony on whether to that issue about whether criminal involvement or something that is created from the environment when they're at DOC. Our testimony was just limited to that as occurring in the EDs.
And I don't see a definition of incapacitated, and I'm wondering, people could be incapacitated for lots of reasons.
Yeah, it's in statute, in fact, and we are further amending this before it reaches the floor to make that language change from inebriate to incapacitated. And so there'd be more refining of that there.
I have one other question, which is, I know you didn't have time to hear from the Howard Center, but that they, during lockdown, ended up combining their crisis program with their PIP program and found that not a good fit because, one, the staffing needs were very different and the client needs were very different. And I know in small counties, if it's just one bed and it's either used one way or another, that will work. But I know the Howard Center had some significant concerns about the state moving in that direction. And
Yeah, the testimony that we did take was from a provider in Rutland that operates both PIP and co-located crisis bed setup. And it was not shared in that testimony. I can understand what you're saying with respect to the position that Howard is in. And it's our hope that as Department of Health and Mental Health, who are working through this 2-year plan, that's done. Obviously, it would be done in collaboration with Howard, most likely as the provider in Chittenden County, and that they can identify a solution. I don't, in the moment, know what they'll work towards, but they will be working together towards that solution.
So, Ian.
I just want to check in on like what we're doing. So I can ask questions kind of about What
So
are,
I mean, I think that, we have to be comfortable enough, or, I mean, if we have, since we have the same issue in a bill right now,
yeah,
we've been keeping this largely to human services because it is more their subject matter jurisdiction than ours. But I think it's fair that we're just kind of hearing about where this program is going. Because we will probably be taking it out of S-109. So we just have to have, I guess, the comfort level that is being dealt with in human services.
okay, and I think my two questions are relevant. So Doug, on the definitions section, like defining, basically moving from public inebriate to incapacitated.
Right.
So in 18 VSA 4802, the definition section, incapacitated is defined, right? And it's alcohol or other drugs. Inebriate or public inebriate is not defined, but it feels like the distinction made by not calling them those individuals incapacitated and inebriation revolving around alcohol, that there was sort of an intention for it to be alcohol and not other drugs. So by expanding the definition to incapacitated from public inebriate, is there an understanding that you're broadening the scope of this to include individuals who are under the influence of other drugs other than alcohol?
I guess I would address it in two ways. One, it's certainly not expanding it how it's in practice.
Okay, well, that's great.
So
Okay.
it is not at all expanding how it's in practice, which, and more, it's dealing with individuals who are incapacitated from something other than alcohol.
Yeah,
And I have not looked at it recently, and it is not included in the language of our current amendment. I thought inebriated had a broader scope than simply alcohol.
it's not in the definition at all. So I
was looking at a different section, but I can tell you in practice, so we did not see it as an expansion of who
Great.
we're bringing into this.
So that's, thank you. And then the only other question I had was, so, of course, I'm gonna have to bring it up. So shall prioritize Chittenden County. So I think I heard the rationale was, well, that's the place that has the greatest need. I think that you could use that rationale for almost everything you deal with in the legislature, that Chittenden County often has the greatest need, right? Because it has the largest population base. So I'm just like thinking about my own county. And if we're talking about, if the definition of public inebriate or now incapacitated people has always included people who are experiencing influence of drugs, like that's a huge issue in my communities. So I'm just kind of wondering, did you guys hear testimony from other counties besides Chittenden County about kind of like how they're experiencing this issue and how PIPs are being involved there?
We did Rutland. We heard the most testimony from Rutland County. We did also hear from up in the Northeast Kingdom, Lamoille County, but that was, in fact, they had recently lost a PIP, a public inebriate program there. We did not hear from anyone down in Windham County, but I think it's also, again, just by the volume, the numbers, and then that melding, if you will, with those scenarios with Vermont's busiest hospital and the ED in Burlington. And so that's where the committee saw that we had hoped that they could move the prioritization from Chittenden County up into year one.
Yeah, because before it was in year two, was
Correct.
And it had language to prioritize Chittenden County, but in the second year.
They didn't reference prioritization, if you will. They just provided us in their presentation a list of when counties were going to be addressed. And when we saw Chittenden County in year two, that sort of caught the attention of committee members, that with as high a need as we have there and no corrections facility for men in Chittenden County, those things combined, and with the impact on the ED in Burlington, that prioritization was appropriate.
In the presentation, they had prioritized other counties in year one.
It did have a list, and I cannot tell you which counties were in year one versus year two, but it had a breakout between the 2 years to address the scope of the state.
And did they talk about what their rationale for why they put counties in year one versus year two in their proposal?
It's my understanding, that there was reference to readiness, but in conversations, not before the committee, but outside the committee room, when that was brought to the attention of folks in Chittenden County, they weren't quite sure where that question of readiness came from.
I have a quick one. Doug, I don't know if it was the PIP operator in Rutland County, but who did you receive testimony from?
Chad,
Serenity House.
it operates from Recovery Housing, the executive director of Recovery Housing, Chad Vijay, I think it's pronounced. Sure.
Barbara.
So did your committee do any like fiscal analysis? Because my understanding is up until lockdown, programs were well utilized. Funding has been an issue for these programs since very early on. Programs did not receive increases in funding, and then cuts came to some of these programs, which made it very difficult for them to keep their doors open. The expense, we know what the expense is if people go to the ER. If they're going to corrections, I imagine there's quite a bit of expense as well. And there's not any service received up until one of the reports. I don't know if this got resolved because the people were not charged. If they did need medical help, they were not. They then would need to be transported from the jail to an ER or a hospital.
But we had a drive-by of the bill in corrections at the end of last week, and there happened to be, as you might expect, DOC staff in the room who were preparing to testify after Chair Wood and I were there. They indicated that there's medical staff there that do attend to, or they do an evaluation when someone who comes in who's incapacitated and simply being lodged there for the evening in the holding area, that they do a medical evaluation. And if that determination is made at that point, they need medical attention, then they would be transported back.
And do we know what the charge is for somebody to be transported and lodged?
We do not.
I'm curious, given the best practice and the research on the public inebriate or sober bed programming, why the committee didn't want to more strongly advocate for that model.
Well, it's not that we're not advocating for that model. And in fact, we're very happy to see the report and the testimony of the Departments of Health and Mental Health about their plan, and having them come in by February of next year to share with us the progress on that plan. I think we were ultimately moved by the fact that all involved, including the PIP operators, that maintaining DOC as an option was a necessary step. It was a necessary component to the bevy of options, if you will.
Maintaining them as an option doesn't require a full repeal.
I believe that's what we're going to be discussing this afternoon when you come before.
I mean, I legally, like, I don't think, because.
So, I mean, yeah, I guess I would frame that more as a question that I had, so I've been holding is that what was the committee's consideration of taking the approach of further delay as opposed to repeal, presumably to put additional pressure on as far as getting these other options?
Well, I guess I would return to the testimony we received from Recovery House Inc. Executive Director, that even with a functioning operating PIP, that he testified there are still times where lodging at DOC is the necessary option, that not everyone is appropriate for the PIP, and that same individual is not appropriate for the PIP, may not have a medical issue, needs to be treated at the ED, but for whatever reasons, the DOC would be the best option if they're proved to be a potential threat. scenario. So with that testimony that it is still sometimes a necessary option, we were comfortable with the repeal.
Because without the repeal, it would ban DOC from taking individuals in this situation.
Correct.
If they were dangerous or not, unless, of course, they were presumably charged with disorderly conduct or something else.
Unless they were charged. And I would say the response,
Septic lodging still, even if they're charged.
Right, right.
the response, there was considerable relief from there was medical director from Rutland, and then someone who represented nurses, and considerable relief that this was voted out of committee in the way that it was, because they have significant concerns about sort of the default that seems to exist at times of using the ED as a place to lodge these individuals.
So, and the push is to have these alternatives, that's what this report is, and that's kind of what you were hearing from AHS. That's
Yeah, from departments of health and mental health. Yeah.
So,
And their intent is to, where possible, look to move to sort of a co-occurring locations where there's crisis beds already, because of, the math isn't going to change on the challenge of operating a PIP as a standalone if you're going to be ready 24/7.
So, right, and that's clearly, I think, in human services purview as far as how that should work, I think so as well.
If there's no medical problem, is there any obligation by the medical center to hold an inebriated or incapacitated person until they're sober? If that were the only treatment is time.
That's a good question, and I'm not sure what the legal obligation would or would not be with respect to them holding. That's the practice, is they do end up holding them for that period of time, and the hold is really generally no longer than 24 hours.
Well, it could be merely as policy of theirs to do it because of liability. If someone were leaving them there and then leaving the premises.
Right.
We can't let them go until they're sober.
And I'm sorry, I don't recall if we received any more detailed testimony about why that isn't the case, but that is certainly not the impression that we received. Is they don't do a medical exam and then street somebody.
Good for now. I know that you're going to be talking more about this upstairs. Other questions, Ian?
No.
Concerns?
I mean, I think I would feel more comfortable if the language around the implementation, around the programming in A1 of section 6 was something like programming shall prioritize implementation based on readiness and need, or something like that.
Right.
And that's going to be Chittenden County, probably based on, but just calling out one county like that, really weird to me.
Yeah.
I actually do that too, and we'll send that as our advice to your committee. Yeah. It's a little clearer. Yeah.
That's our soul here. So
So yeah, I saw that. I did
Send them
realize
in
somehow
the
that
afternoon,
somewhere.
but not here.
Said Chittenden County. Go ahead, Tom.
Well, I was just, it's just pandering. Yeah, I have done a lot of incapacitated individuals. For 30 some odd years. And it all started in Burlington, Act 1 alcohol crisis team, and you would bring them and they would, screen them and keep them if they were behaving or not. And then it was jail, or it was a hospital first. But jail was always a very necessary part of the equation with some people, because they just could not be handled anywhere else when they were at a certain baseline in their level of intoxication, just uncontrolled.
Right.
So to have that part removed, that would leave us in a bigger problem. Oftentimes we'll leave somebody that we don't know at one of these facilities, even with the worker, okay, and they call back 30 minutes later saying, you gotta come get them.
Right.
So, problems. as far as the transporting goes, like whether it's the mails in Burlington, it has to be done, and you're not burning any more gas or time. It's just time off the street.
which is important as well.
Right.
But, so, I mean, this really is more human services, subject matter jurisdiction. You know, I think it's kind of been in 3 different committees, but ultimately somebody's got to make the final decisions. And, you know, we've given you some of our input. I know that at least one of our members is not pleased, but it's separately going to human services with an amendment proposal that I appreciate that folks are taking up this afternoon. But I think as far as from here, I think the main thing is, are we fine to be taking this out and leaving it to human services? I think that, you know, if they're doing a thorough job, we'll probably be taking it out of our miscellaneous bill. We'll leave it in there until we see your path. You know, if for some reason it gets hung up for reasons I don't know about in the Senate, you know, but by the end, when we're sending this over, I would imagine we'll be taking that component off of all of this stuff. So that I'm seeing most people nodding, so we'll leave it for that.
It had come out of the Senate with our understanding that they had not taken testimony on this component of the bill. So, but we had 11 witnesses come before the committee and offer testimony.
Appreciate that.
Yeah.
Thank you very much for your time.
Yeah,
We'll
certainly.
look forward to your report on the floor now. We'll have all sorts of questions and interrogate you and all that.
I'll bring my wife back that day.
Yeah.
Take it easy on me.
Thanks.
Yeah, thank you all.
If you can get us started with the like. I just, yeah, before I get my then.
It doesn't matter, I'll get it at the end.
What were you getting?
The amendment,
Okay, we're gonna go to page 86, and that's relating to establishing the chloride contamination reduction program. And Michael,
Thank you.
good afternoon. Did I begin?
Yes.
Okay, this is Mike O'Grady with Legislative Council. You should have draft 5.2 with a 4/22 date and an 8:04 a.m. timestamp. So I'm just going to step through the changes unless you would like a more detailed review. Okay, so page 1, line 7, section 1. At the directive of the chair and after your discussions last week, a purpose and intent section has been added. It's the purpose of the act to establish the accepted standards of care, the application of salt and salt alternatives in an effective and efficient manner that provides safe conditions for pedestrians and motor vehicles on traveled surfaces while also reducing the impacts of salt and salt alternatives on the quality of the water so safe. So that is basically what you direct the agency to establish the program to do. Very similar language. But the second subsection, it is the intent of this act that a person's compliance with the standards of care required under the act shall limit the person's liability in negligence lawsuits. So if this goes to rulemaking, if there's a question of legislative intent of what the standards are required to do, you have this statement of legislative intent and what those standards are to do to inform LCAR. Should I move on?
Yes.
So moving on from there, the next change is on page 6. In the limited liability section, previously there was a date where you were going to have the limited liability initiate, but after your discussions and contemplation of LCAR and knowing that you're directing the agency of natural resources to adopt the rule by July of 2026, That rule will then go into place 45 days after July 2026. They'll have that time to set up the program. Whenever the program gets started and whenever applicators get trained is when the liability will attach. You don't need a date to direct when liability will attach. It will attach once the program is up and operating. So moving on from there, on page 7, it had line 1. The language had previously said protection from liability, and Adam Naprasan last week said for consistency, it should say limitation on liability. And there had previously been another subsection C where all certified applicators were presumed to be acting pursuant to the BMPs. You don't need that again. That was Adam's testimony. It was superfluous with the program. And once you're certified and you're applying according to the BMPs, you don't need that rebuttable presumption. And then that allows you to go to the municipal salt applicator section on page 10. This is where those municipal salt applicators who are trained under the Vermont Local Roads curriculum are being taught the best management practices. One of the things that was not part of the requirement for them was that they keep the same records as the commercial salt applicators for purposes of maintaining their liability protection. And so what was added, page 10, lines 15, going on page 11, very similar language to what is required for the commercial salt applicators in order to maintain the liability protection. The municipality shall keep a record describing its winter road, parking lot, and property maintenance practices consistent with the requirements determined by the Secretary under the Vermont Local Roads curriculum. The records shall include the type and rate of application of de-icing materials used, the dates of treatment, and the weather conditions for each event requiring de-icing. Such record shall be retained by the municipality for a period of 3 years. And that is the last of the changes other than renumbering the section numbers to account for that new section 1 of purpose and intent.
Question.
I'm curious, how do we liability for an operator? I mean, are we giving them an insurance policy or are we just making them not responsible? How do we do that?
You're saying that if there is harm that's solely from the snow and ice and the harm is caused allegedly from delay or practices that are required under the BMPs, that they will not be held liable for that harm unless a person can show they weren't complying with the BMPs, that the harm wasn't solely from snow or ice, or they were grossly negligent or with acting with disregard. So you were saying that they have that protection, but they're not immunized.
So you can still file suit.
You can still file a suit.
Here.
Right. Yeah, kind of.
Do I remember right? This is voluntary sign up.
For the commercial salt applicators, yes.
So small business, mom and pop operations, for lack of a better word. How does this affect them?
It doesn't need to affect them. What may happen is that over time, the BMPs are judged to kind of be the standards for snow and ice application in Vermont. So it might affect if there was litigation, if they did harm someone and they weren't a certified commercial salt applicator, a plaintiff can say you weren't following these best management practices and therefore you were negligent. But right now, that would take time to evolve.
So I think what I just heard out of that is with this being under jurisdiction, for lack of a better word, that anybody that wants to bring, this makes it well known to anybody out there that wants to bring a lawsuit towards anybody, like the small mom and pop operations, they will go after them. And they'll blame them for not signing up for the voluntary so-called protection. Does that make any sense to you, what I just said?
Well, the opportunity for litigation really depends on if there's harm. And so that opportunity is there today. This doesn't change that. An attorney or a firm or a plaintiff that wants to seek damages, they have that opportunity today. Will these BMPs become part of a discussion or a review by the court of whether or not they are meeting the standards of care? Probably.
But I guess what I'm trying to get at is the small guys, the ones like I talked about last week that are doing this as a side business in the winter or whatever. They probably wouldn't invest in this or be able to afford this, or certainly charge their customers more money than what it's already costing. Plus, we have a lack of these people that are doing this application anyway. Because most of them are using, their summer vehicle. They're putting the unit in the back of the vehicle, if it is available, with the new technology that's required. I assume you're probably going to have a newer vehicle to monitor this stuff too, right?
Not necessarily. The best management practices are supposed to be set up so that they can be used across the spectrum, including using paper documentation for the record keeping when you arrived at the site, how long you were at the site, how much de-icer, salt alternative, salt you put down. And so that's all easier when you have newer equipment and you have the technology, but it is not impossible to do without that technology. And remember, it is still voluntary. If the mom and pop doesn't want to do it, they don't have to get certified.
That just throws them out there for a bigger lawsuit that they can't. I mean, they're tied up in litigation, they can't afford it, and all that stuff, and then it's like, I just think we're gonna lose a lot of people. I realize the intent, I get the intent. I have serious concerns with this, how it's going to be utilized, how it's going to be watched, how it's not going to be abused by litigation. And I just don't think a lot of people are gonna do it. They're gonna just forget, I'm not doing it anymore. The other thing I just thought of is moving forward. I mean, we have we're still under these mandates of this of the
TMDL,
what?
TMDL,
What's that?
TMDL. So is that what the mandate you're thinking?
Yeah, I think so. Tell me what it is.
Total maximum daily load.
Now, the vehicle emissions,
Clean trucks.
yes, thanks. I'm struggling, just something a lot, right? Because we're still looking at that there, and there's a lack of vehicles out there already. I don't know how we're going to attain all these goals.
Well, clean trucks, from my understanding, I'm not working on the issue, but there might be some movement to open that window a little bit. I'm kind of speaking off the cuff on that, but I don't think you've heard the end of that discussion.
What? I'm confused what clean trucks has to do with the salt.
It's about whether or not if you want to get certified and you need to get new equipment or a truck that has GPS capability, whether you're going to be able to get that truck because A, it's either too expensive because it's clean truck, or it's just not available anymore, or in smaller supply because of the current economy and supply of automobiles.
Yeah, if I may.
Yeah, well,
I believe we're under a big shortage of supply of these vehicles already. That's where I was going with that, Tom.
But I'm not sure how this bill would impact that. I
You
mean,
need
so-
vehicles to,
right, there may be fewer people
To
who may
spread
be
them.
able to voluntarily do the program and take advantage of the limited liability it provides.
but again, Chair, I stated, I believe last week, there's fewer and fewer of these people that's doing it already, like just to get my driveway plowed. Like it was supposed to be 7 o'clock in the morning and it's like anywhere from 11 o'clock to God knows when to get my driveway done. And there's even less people that's going to do it now. That's just the plowing end. Well, and then when I need sand that has a mixture of salt in it, it's just raising more of a huge concern. And we all know that, that I believe we had this initiative taken a couple of years ago that roads were supposed to be cleared or something like this, that, you know, we were, as far as I was concerned, we were kind of overdoing the plowing and the salt treatment and all that stuff, which probably got us to this level too, even though that's kind of exempt.
But they moved away from the total removal of snow and ice for AOT. It's a safe road standard now. And they are implementing what's called the TS4, which is a permit, that their water quality permit on state roads, and it has a chloride aspect to it, a chloride control aspect to that TS4. And so they do, and I don't know if you were here last week, how I talked about how the state plow drivers, they're trained on how to do application. They have GPS systems, they have geofencing. When they enter areas where there might be salt issues, the geofencing requires them to adjust their equipment. They also have people that follow them to see how they are applying their salt and their brine. And so there is already a program at state level with pretty comprehensive training and review.
You did at the state level. Municipal level. And individuals is another big thing. Unless you're a big outfit this is what you do in the winter, and construction outfits for the most part, that is offsetting. It's what they do in the winter. You know, your big parking lots of the.
Yep, landscaping, I've done it myself.
Tom and Tom.
good job.
Have you heard, through any of this, I guess, I could see some dedicated people who do this on a regular basis throughout the winter. Who may not carry insurance, thinking this could be helpful. Has there been any sentiment to that?
I think, I wasn't here for your testimony from New Hampshire, but that is something that when I saw New Hampshire staff testify, that they've heard from the commercial applicators that they're welcoming it. it's establishing standards that they have to train their employees to, and they get liability protection for that. And when there is litigation, they have the ability to say, here are our records, here is our proof that we were operating the way we were supposed to, and we should not be held liable. And they have a case study. They have a case where it played out there. I do know in certain states it's a little bit more, it's a little uncertain, and that's usually because of the differences in the state programs. And the state I'm thinking of is Illinois, where they just say that you can't be sued for snow or ice removal. Period. There is no standard. There's no what you would need to do, how you would be certified. And so it obviously, people get hurt, and they're looking at ways to implement that law and still provide a remedy to those who are injured. And so I'm not saying these laws are perfect. I think they take some time to implement. This is much closer to New Hampshire's law than it is to Illinois' law.
Illinois law doesn't sound like it's gonna do anything to prevent salt or sodium from getting into the water.
Right.
Now, the difference between state and municipal and your commercial folks and whoever else are doing it. I can understand the state and municipalities using geofencing and all these other things. Is that gonna be a reality for the little guy too? I mean, if you're doing a parking lot that's 4 miles from any other water, you know what I'm saying, I guess. Could they use an app on their phone versus having to have all this expensive equipment?
I'll be honest with you. I was debating this with my 17-year-old son last night about how to use geofencing and whether geofencing was appropriate. And he said, and he's much more technologically savvy than I am. And he says it's all dependent. And he literally called up an offshore gambling site. And I'm like, where did you get that? He's like, my buddy does this. And I'm like, that's supposed to be geofence. You're not supposed to be able to get that. And he's like, well, that doesn't always work because it's not always enforced. But there are apps that can, and there are apps that do geofence, and like the sports betting apps, they geofence. So yes, there's opportunity for that. Is it going to be perfect? That was my son's point. And you're probably going to have some opportunity where something's not going to work.
Time to time.
Right.
Now, my other one other question was, did snow come up in any of this? I mean, a lot of these people are doing snow removal. I mean, do they receive limited liability protections if they're just removing snow, but if they do salt and snow at the same time in the same place, but they didn't do it that time?
I can't answer that because I don't know what the BMPs are going to be yet, right? And so we need to figure out what the BMPs are going to be, and that's why.
Or somebody who simply does snow removals subject to liability, civil liability actions.
If they're only doing snow removal and they're not doing salt application, they could still go through the commercial salt certification program, and then it would be about whether or not the BMPs that were established were appropriate for what they were doing.
Whether or not it needed.
Right. Right.
Can I just touch on one part that he said? You may have to
Go ahead.
Go ahead. I'm going to touch on something that you said, but I'm waiting. So, being a former Vermont State Certified Pesticide Applicator, I didn't have fancy equipment to tell me exactly how many gallons I put on a lawn. You could guess by looking at the tank, or maybe guess how many pounds of salt you used by looking at your sand or spread or whatever. Once you've I think the statute of limitations is up for me. But once you've done a lawn so many times, you know about how many gallons you're gonna use, and you can go back to you can look at the square footage. And with that amount of square footage, this is how many gallons you're supposed to use. And that's the way you do your paperwork. You're not putting extra on by any means, but you're pretty close with the application. And I can see it working exactly the same way with people spreading salt. With, if you don't have the equipment, there's gonna be estimates. And the estimates are gonna be pretty close where, and if an inspector came out or whatever, your butt's gonna be covered. And I don't think there's gonna be a big issue with the mom and pop people. So the bill as a whole, I have an issue with, because with all the, the rulemaking and all this, we heard from New Hampshire, everybody I think agrees, they got one heck of a program over there, and it seems to be working pretty well. So I don't see why we don't plug and play it for less than $100,000. We're not just, if we take their program and plug and play it, we're doing it for under $100,000. We've got $250,000 in it. And on some level, we're reinventing the wheel. And our geographically, with mountains, I mean, they have the coast, which is different, but we're pretty close to the same type of state. And I don't see why we have to reinvent the wheel. It's almost like we could take their law and just go, here it is for a third of the money, and away we go.
Well, I think the question of the appropriation is going to be subject to every appropriations review. And I understand there's not a lot of one-time money for new programs right now. So I don't expect the 250 to remain 250 unless you all really want it to be.
No, I understand. It wasn't a question to you at all, but I certainly appreciate your input on it. But more or less venting my frustration.
So I would suggest on that issue as well to look at the written testimony from A&R that we have on, because they touch on that. They touch on the importance of the rulemaking, but they also touch on the money part and recognizing that they probably aren't going to get the money. So I mean, we could have A&R in still, but I mean, I think our issue is really, are we comfortable with the way the liability component is set up? That it is a rulemaking that's going to get, through that process, which A&R supported. We're going to see what standards would apply. There'll be opportunity for people to weigh in, including the Attorneys Association and others. And it's only after that it will go through through LCAR, so that legislators will have an opportunity to weigh in, given what we're putting down as an intent. And then we added that for the municipality. So I mean, that's kind of our lane as far as, and I'm kind of wondering, are people comfortable with that component? I mean, there may be discomfort and people may be voting against this bill, whatever it said, but just as far as how we've handled the liability question, I mean, where are we with that? If anybody wants to weigh in, Ken.
Okay, so Tom just brought up exactly where I was going. When you were doing your business, you weren't commercial, were you?
Yeah.
Or you were commercial?
I had a commercial, Vermont State, pesticide commercial applicator business.
Okay, so where I'm going with this whole thing, when you were talking, the word commercial was used up, and then we went to Illinois, and I'm saying, okay, the commercial guys are covered, because usually they're the bigger guys, and I assume you probably had a bigger operation than you were.
Just me. One guy can be commercial.
Right. So that's,
That business.
that's a component of the pesticide rules, the state pesticide rule. If you're going to be offering services for the application of pesticide, you have to be certified, especially you have to be.
Commercial.
And especially if you're using certain types of pesticide.
Okay, so that's good on that. But you don't have to be listed commercial for mom and pop operations of plowing, salting, sanding.
But they are commercial. If they're offering their services for compensation, that is a commercial application.
Yeah, I get it, but a lot of them.
But remember, the term is used here only for the purposes of whether or not they're going to voluntarily enter the program and be certified.
I know, and I'm just circling back around because a lot of them, I just don't think they're going to do it. And then everybody knowing that they could have been, is just gonna bring up more losses. It's a catch-22 situation. And
So is it concern that people are gonna be sued if they don't join this program?
yeah, they're the small ones. They don't buy the insurance. They don't buy the insurance anyway. Like you go and you'll see advertisements out there like, oh, must be insured, must be insured. And there's so many people that they're not gonna plow that driveway because they don't wanna deal with insurance. They don't wanna do any of that stuff. I mean, when I had to plow on my truck, well, it's all mine was favors because I'm whatever.
So.
Exactly, yeah. Yeah.
Karen?
So I was just gonna, I feel like we can have lots of conversation on this, but I feel comfortable where we're at. I feel like we put a lot of time and energy and witness time into this. And my understanding is that we reviewed this part of it. It's gonna go back to Environment Committee. They kind of review what, correct me if I'm wrong, they review what we did, but then they're the ones passing it out.
Correct.
So, and if they changed any of the sections that we did, would it come back to us that we would have a chance to look at it or?
Presumably, yes.
Okay,
I mean, if that they've been reaching out to us for our judgment on the liability section, which is within our lane. You know, it's our subject matter jurisdiction. So, yeah, we're giving that input. I mean, we could also do a straw poll on this, I guess, but I'm not sure if we do that or if we do a straw poll once they've finalized it. Any opinion on that, Mike?
I realistically, I think you could do it anyway, either way, because I don't think they're going to change it much once they get it back. But if you want to just be very careful, you would wait until they've actually voted it out of their committee.
So I think we're good. Ian?
wait, can I finish?
Sorry.
Oh, yeah, Karen, yeah.
And that day is our last day to talk about, and then we're sending it, saying, okay, or environment, it's back to you and let us know when you're done with it.
Yeah, we'll just take a quick look. Hopefully a quick look. And Mike can come back and say what, if anything, has changed from what our recommendations were. Ian and Tom.
I also feel good with moving forward. And even if there are effectively no changes, we can still have it come back to us to do a strong poll.
Yeah.
And then my only question, based on the changes made for today that we're looking at, the purpose and intent section, the language is very similar to just what was already in section.
Right. For subsection, the establishment of the program, yes.
And so this shows my ignorance. So I don't really, is the language that's in the establishment and purpose also legislative intent?
Yes. Yes.
Um,
And be frank, the courts have been using whatever they can find for legislative intent, like act summaries, section by section summaries. And we literally write on our act summaries, this is not for a legislative intent, but they are still using them for that. This is a specific legislative statement that has more weight than a lot of what they've been looking at for legislative intent.
Okay, so even though it's very similar to some of the other language in here, by pulling it out and identifying it,
Calling it the purpose,
Calling it the purpose.
saying it's the intent.
it plays its own role.
Yes.
Okay.
So Tom, then Ken, I'm sorry, Tom was next.
Yeah, respond to it. Finally, lately, I don't remember, but are the records only presented in the case? Were they corrected or annually?
So when it was first drafted, there was a requirement that the records be submitted annually, but that's no longer a requirement. That A&R didn't want that to be something that they had to manage. It's for the applicator or the business owner to maintain those records, and they have to maintain them for 3 years. There is opportunity for A&R if they were going to do some sort of oversight, they could ask for the records. But remember, the only enforcement here is revocation of a certification. You're not going to be enforced against.
And how much do you have to divulge if there is a claim, or is it on a case by case basis what they're going to?
Well, if there was litigation, how much? Well, that's going to be fact specific. I can't really say.
Okay.
So I'm gonna go back to what the vice chair said. If for me to get on board with this, he brought up if New Hampshire is doing this and doing it such a good job and it's only 100,000, why are we charging so much? Why do we need to charge so much? And we ought to, I forget his exact words, but we ought to be following what's already out there, not reinventing the wheel. I'd be much more in line with that than, what's this, 300,000? Or 400,000?
250 for
Look
the
at it, yeah, right?
contracting and 150 for the position.
Yeah, so that's 400,000. I'm sorry, what'd you say?
If I may,
Yeah.
is that, I feel like this is one of the examples of it gets tricky where we have the policy in front of us. So we are making the decision on the policy, and then appropriations will have to decide if there's money for it. So we're basically saying, we check the box, like, yeah, we support this policy. Appropriations, if there's money available and you think it's a fit, then you fund it.
Well, I would go even narrower than that. We are looking at the liability component.
Yeah.
And whether we got that part set up right. I mean, whether this is the best overall policy for preventing us from getting TMDLs, that's not us. But does the liability work with our different tweaks that we've had on this? That's us. So,
That's what you were going to say.
anything else on this one? All right, so we'll have a very brief drive-by when something actually is on its way to the floor. I don't think we're gonna get Eric until 3, so we'll, and when we have Eric, it's gonna probably be very, quite short, so.
We can ask more questions for a while.
Well, yeah.
So before we adjourn, Michael, these, the sheets that you're gonna write the reports on, and the amount of salt, would you have a copy of one of those?
Yeah. All right.
Bye-bye.
So before we take a break, so we're gonna do S 109, which is the miscellaneous bill. Mainly there's, and we'll have, we'll get a draft. Do you have the draft?
Yes.
There you go. There's, some amendments. We're gonna have Eric walk us through the amendments, given, the input that we've gotten already. I'm hoping that I can hear from folks as far as if there's any issues that they have with any of the sections, so we kind of know where we are with it. There is one decision point that we need to make, and I'll just mention it now, but we'll see it in the bill. And that is, whether in the firearm relinquishment compliance working group, or is that one of the task force? I can't remember which.
Okay.
Yeah,
They're
that
the same thing.
within that one, the membership, whether we understand that there is an FFL, the Attorney General's office has reached out to an FFL, is willing to be part of that group. The question is really, do we have the Attorney General designating this FFL? Or do we have the Sports Federation? Because I don't think we have both, because that's, you know, whoever's not there will be part of the consultation. But that's one decision just that you can, is one of the main kind of decision points that we still have on that bill. Just to flag that for you.
Right now, they have both in.
Either or. It's like, it's in the draft bill, it's something, you know, FFL as appointed by Attorney General or Sportsman Federation. It has it both in the membership and then on the consultation. Whoever makes it one, you know, it's,
Oh,
you know, we'll
that's
be,
what you decided on?
well, it's either, well, no, I think we have to decide which one do we want for it. Which
Oh,
one do we
oh,
want
okay.
Consultation, which one do we?
Oh, the question.
I would say federation be on the board. Because they're there for different reasons. One is just one prong of the wheel.
Yeah, we can talk a little bit about that further as well. I understood that we were putting the federation there specifically for the so-called back end, which is the FFL part. I mean, that's what I kind of was hearing from the federation witness as well. So that's part of the balance. But we can see the language and we can.
You're gonna have to do better.